Listen to this clip of InShort's founder on the Think School podcast regarding fundraising, and then I'll break down the law on it.
3 महीने बाद
इससे पहले मैं ये पूछना चाहूंगा भाई कि फंडिंग कब रेज करना चाहिए?
फंडिंग कब रेज करना चाहिए? आइडियली तो अगर आप जितना डिले कर पाएंगे उतनी अच्छी बात है,
जितना डिले करवाओगे उतना अच्छा
उतनी
है।
अच्छी बात है।
Now, I also, as a corporate lawyer, will actually advise the same to a first-time founder, especially in cases where the investor is asking for too much legal control of the startup or too much legal protection of the money that he's putting in the startup in the form of, let's say, a liquidation preference clause. And that is because what the liquidation preference clause does is that it creates an obligation on the startup/company to pay back the money that the investor has put in case the company is being sold off or the company is shut down. But the liquidation preference clause by itself probably is not the problem. The problem is the intensity of the liquidation clause, which can be increased and decreased just like volume. Now, for instance, let's say there is a liquidation preference at 1x and the investor has put in 20 crores in a startup and now the startup is being sold for rupees 60 crores. In this case, the startup has to return back the 20 crores to the investor first, and then the remaining 40 crores is going to be divided amongst the shareholder. But let's just say in the very same situation, the intensity of a liquidation preference is increased from 1x to 3x. Then in that case, the startup, if it is being sold for 60 crore rupees and the amount that is invested by the investor is only 20 crores, the startup will have to return 60 crore rupees, which is a 3x of 20 crores, to the investor back, which means that no other shareholders, including the founder, make any money. So in short, if you are an early stage startup founder who's getting to raise funds but on such terms, then it is much more ideal to just delay the process for now.